Next, we're going to move to Senator Lombardi's bill, Senate Bill 389. Senator Lombardi.
Thank you, Madam Chair. This is one in many efforts by this committee to address the issue of expungement of records. In this particular case, it clarifies or quantifies certain areas of felony convictions where a party can file a motion to expunge their criminal record, most predominantly when it's over 20 years old in certain areas. And I would point out that it certainly excludes felony convictions for crimes of violence.
Thank you. And we do have witness testimony on that bill, but I'm also going to introduce my legislation, which is Senate Bill 606, which also has to do with expungements. As Senator Lombardi mentioned, this committee in the Senate has been very committed to the justice reinvestment pathway, and this legislation is building on the work that we did in the cannabis legislation last year to expand the category of expungements, automatic expungements, to nonviolent misdemeanors. For me, I think this is really kind of the common sense next step to try to build upon that work of automatic expungements. I know some states have moved to a fully automated administrative process for doing expungements, and that takes that administrative burden off of the person who is eligible for expungement but may not be able to navigate the kind of administrative hurdles of going through the current process with the judiciary. So with that, I'm happy to entertain any questions on Senate Bill 606. Seeing none, we will move to public testimony. We have one person signed up on Senator Lombardi's bill 389, Jeremy Costa. If you want to come up, and you're welcome to testify in my legislation as well.
Yeah, I think I signed your legislation as well. And again, you're going to see me a lot. You're going to see me a lot. And the reason why I actually, if there is no expungement, then I happen to agree with this bill. If there is an expungement bill, then 20 years, I think, is just, I think is a little excessive. For instance, I actually am up for expungement because I'm looking to run possibly for office. Now, on 514, my expungement is, I'm eligible for expungement. But I was in front of the courtroom the other day for disorderly conduct, yeah, maybe it was disorderly or disturbing the peace, one of the two. And I told the judge that I'm not taking this charge. I'm not taking this charge. It's a First Amendment violation, and I'm up for expungement on 514. And so we'll have to take this to trial. So what happened? They dismissed the case because the officer didn't show up, and they just filed it, continue without a finding. So I don't know if 20 years is too long for a felony, because 10 years usually, it says in the Bible, let's not use 10 years, let's not use 20 years. I want to know where 20 years came about, because in the Bible it says, thou shalt not show partiality to a just man in his dispute. And after 7 years, you can forgive me of my debts, you can forgive me of all of my inequities, but you can't forgive me of the crimes that I've committed if it was a felony, that was nonviolent. Maybe they were going through something during that particular time. So you guys are using scripture to write your base, to write, or I don't know if it was scripture or the Magna Carta or what, but you guys definitely constructed these laws out of somewhere. And if you're not using the same basis as scripture, then this bill really has no merit. Now, if this is open an opportunity for expungement, I think that it should be 10 years if the person has been law-abiding.
Jeremy, excuse me, I don't mean to interrupt you. The reason for the 20 years is that these people otherwise would not be eligible for expungement
at all,
because it's multiple felonies.
Right. No, this is a bill that I am very concerned with, because I have a 2003 possession of marijuana case in Pawtucket, Rhode Island, and I am up for expungement on 5/14/2023. Right. So this is the 20 years.
Question, this will make people who were not otherwise eligible for expungement to be eligible for expungement.
Right. So that's the case, and this is the case, and this is an important case. That's why I say 20 years is not enough. 10 years should be the window. It shouldn't have to be 20. If we have to start with 20 to get this in the books, then we should do 20 years. But you guys need to start considering reforming these bills. This is a good bill. If they're not eligible, and this is going to give them at least some way to get eligibility, you need to consider this. And you need to find out how we can get a companion bill in the House immediately for all of these bills. Most of these bills are pretty good besides the Burke bill, I happen to agree with a lot of these bills. So we need to get rolling. We need to stop filing it for, further study. We need to get them to a roll call, get them on the floor, and let's get going. That's all I want to say. But yeah, the expungement bill, that is ridiculous. With the cannabis, are we mentioning any of that?
No.
Multiple felonies don't allow expungement.
Correct.
Right now. Yeah, that is horrendous. That's horrendous. You could have 2 possession of marijuana charges for different times, and you still are not eligible if they were more than an ounce or 2 ounces. That's crazy. When you guys are selling an ounce every 2 seconds. So you guys need to really consider looking at those laws. Thank you.
Thank you. Harrison, did you want to testify on Senator Lombardi's bill?
These damn mics. I would like to testify in support of your legislation.
Okay, before we do that, I just want to check and see if there's anyone else here who would like to testify on Senator Lombardi's bill. And with that, that does conclude the public testimony on Senate Bill 389. And move to hold by Senator Lombardi, seconded by Senator McKinney. All those in favor? And Senate Bill 389 is held. Senator McKinney, would you like to be recorded in the affirmative on any bills you missed? Yes, please. Thank you. And the clerk will take care of that. Next up, we're going to finish the public testimony on Senate Bill 606. I know, Mike DeLauro, you said you were going to come up later and grace us on a later bill. So
I was on the bail bill. This one.
Okay. Yep, coming up. And then we also have Chris Boyle. Go ahead, Harrison.
Thank you, committee, for having me again. My name's Harrison Tuttle. I'm the president of BLMRA PAC. BLMRA PAC is in full support of Chairwoman Oyer's piece of legislation being heard right now. I want to really talk about how important and impactful expungement of criminal records are. By having expungement of records and for having this movement not only here in Rhode Island but nationwide, we're opening doors to folks who have had their doors closed when it comes to access to employment, access to housing. When someone serves their time, that time should be served and it shouldn't carry with them for the rest of their life. And so this piece of legislation is one step in making sure that folks who are seeking a better life can have access to that better life and not have their criminal record affect or their past affect what they're trying to do and better themselves. Thank you.
Thank you. Are there any questions for this witness? All right, I don't see any. Mike, go ahead.
Thank you, Madam Chair, committee members. Just briefly, I want to say that this is clearly a trend in the law to make it easier for folks to getting their records expunged or sealed, for that matter. Last year, this body passed a piece of legislation that the in my previous life, I worked on as a public defender. Had the pleasure of working with Mr. Boyle and the courts to make it, when a case is dismissed via District Court Rule of Criminal Procedure 48A, that the sealing of that case becomes automatic. So folks don't have to go back to court a second time and to have that done. There's legislation this year to adjust the time frame on that. That's for another day. And clearly this is a trend because I think the inspiration comes from the marijuana law, which, as you know, provides for automatic expungement of eligible prior convictions for marijuana offenses, and includes even dismissing counts that are that would otherwise perhaps not be eligible for expungement. So I'd be happy to answer any questions you might have.
Thank you. Are there any questions for this witness? Senator Lombardi.
Just a comment. Mike, you and I always have this give and take in this committee. I just want to congratulate you and applaud you on your tremendous service to the state of Rhode Island and all the people who are less fortunate to be able to hire private legal counsel at the Department of the Public Defender. And I mean that. I applaud you for all those years and decades if you've done that. Thank you.
Thank you, Senator. It means a lot to me that you said that.
Thank you. And Chris, welcome to the committee. You want to go ahead?
Thank you, Madam Chair. Chris Boyle on behalf of the Rhode Island Judiciary. I think our concerns about the 606 relates more with process than with policy. As Mike indicated, we've worked closely with many parties to make expungement easier for those who are eligible. The problem with the automatic waiver, and by the way, as you know, cannabis is on automatic expungement, and the courts are having some struggles dealing with how to handle the volume of that issue. But the courts have made efforts to make expungement easier, but in this case, there is a process that has to occur where the courts have to find those elements where a person is eligible for expungement exist. The 5 years, there's no crime of violence, it's a first offender, no restitution owed. Those kind of elements have to be established, and really the only way to do that is before a judge in court. They have made the forms available online for individuals, but they can't seem to find a way to satisfy the ability of the courts to find that those elements exist that make someone eligible for expungement without some sort of face-to-face hearing before a judge.
Thank you. I just have a quick question. Do you know, have the courts looked at the process that has unfolded in Pennsylvania after they passed their clean slate legislation in 2019?
I'm not familiar, but would happy to have that conversation with you.
Thank you. I appreciate that. Because I know that there's also a bill pending in New York, and I think about 6 other states that would do just a full clean slate process that would just completely automate the process from the perspective of the person who has the record.
Right. We're familiar with other states. The issue, as you identified, is the automatic and the systems that the courts utilize now that just is not possible under the system that they have.
Okay. Thank you. I look forward to continuing to discuss this.
We will reach out.
Thank you. Any other questions or comments for this witness? All right. Sorry.
Does not exist for marijuana. Is that what you're saying?
No, sorry. This isn't a back and forth opportunity. We can have discussions outside of the room, but this isn't going to be a group discussion. Thank you. We have Nina Harrison, who signed up in support, not testifying. She's with the Economic Progress Institute. And that does conclude the public testimony on Senate Bill 606. With that, I'd entertain a motion to hold, moved by Senator Lombardi, seconded by Senator LaMountain. All those in favor? Aye. Any opposed? And Senate Bill 606 is held for further study.